Subscribe to our channel and press the bell icon so that you never miss any video lesson from Rao's IAS Study Circle. Join the official Telegram channel of Rao's IAS Study Circle to stay updated and get all the materials on the Telegram. The link to the channel can be found in the description box. Hello and welcome to Daily News Simplified, an answer to what, why and how of newspaper reading from UPSC Civil Services examination perspective. Today we will be discussing some of the important news which has appeared in the New Delhi edition of the Hindu newspaper dated 23rd September 2022. These are the list of the news for today's discussion and their timestamp has been provided in the YouTube description along with PDF. So let's start our discussion but with an important announcement. Hello students. There is an announcement for you regarding the optional classes which we at Rao's IAS are starting at Bengaluru and New Delhi Center. The optional paper of Public Administration will be taken up by Anubhav Sharma sir at the Bengaluru campus on 26 September from 3:30 p.m. For the history optional subject, orientation class at the Bengaluru campus will be taken up by Parampreet Singh sir on 27th of September from 3:30 p.m. And the orientation for geography as an optional subject will be taken up by Indrajit Bariyar sir on 27th September from 6 p.m. So these three subjects will be taken up at Bengaluru Center. Shobik Sen sir will take up the optional classes for psychology optional at New Delhi on 28th of September from 3:30 p.m. And this will be followed up by the orientation class of sociology by Dr. Surendra Singh sir on 28th of September from 6 p.m. onwards. On 29th September, the orientation class will be taken up for PSIR optional by Rahul Puri sir from 3:30 p.m. Whereas on the same day, that is on 29th September from 6 p.m. onwards, orientation classes for the history optional will be taken up by Kritika ma'am and Mathimaran Raju sir. Next, on 30th of September, the orientation class for public administration will be taken up by Dr. V.K. Kaushik sir from 3:30 p.m., which will be followed up by the orientation class for geography optional at New Delhi campus from 6 p.m. on 30th of September by Vineet Thaplu sir. Now these orientation classes will be conducted both online and also in the offline mode. And these classes you can interact with your teachers about the optional subjects, the nature of questions asked and also the syllabus provided by UPSC. Now let's start our discussion with these two articles appearing on page number 8 and page number 9 regarding internal democracy of a political party. So this news appearing in the editorial says that Election Commission of India is right in rejecting the notion of leader for life in political parties. So the news highlighted in the editorial is that the Election Commission of India has rejected the idea of permanent president for any political party, in this case the YSRCP of Andhra Pradesh. And the Election Commission had to reject this idea of permanent presidency because the political party, that is YSRCP, elected Chief Minister Y.S. Jagan Mohan Reddy as its president for lifetime in July 2022. So there are a number of questions which obviously arises in this particular case. Number one, of course, can any political party appoint any person as their lifetime president? And based on this, the second point of discussion becomes, is Election Commission empowered to regulate the internal functionings of a political party, including their conduct of internal elections? So this particular editorial goes into this aspect of lack of inner party democracy in political parties, particularly the regional parties of states. Whereas this particular article appearing on page number 9 is more of an interview between former Chief Election Commissioner of India, S.Y. Qureshi, and Rahul Verma, who is a political analyst. And both of them discusses in detail about the role and importance of Election Commission of India to regulate inner party democracy. And in the process of their discussion, they have also highlighted examples of United States. So from our examination perspective, this topic of internal democracy becomes very important, and also the conduct of political parties. Now why it is important? Because it is these political parties who ultimately win election and run the government. So since these political parties also become a part of the government process, and hence it is very important for them to be internally democratic and follow and adhere to the democratic principles. Now talking about internal party democracy, we very seldom hear about the elections or internal elections being conducted by different political parties. and of late in this regard, there is a buzz for the conduct of elections within the Congress party for the post of its president. So in our multi-party system, where there are national parties and there are also regional parties, most of these political parties do not wish to conduct these internal elections on a regular basis. And the reasons are many, including the culture of high command or a family having its own administrative and financial clout over the entire functioning of the political party. So mainly there are two aspects with respect to the conduct of internal party democracy. The first is regarding the internal structure, whereby the procedure to determine the party president is not very transparent and functions around a group of people who function very closely to the high command or a group of people from a particular family who basically runs the entire political party. And this aspect leads to the second reason, which is the centralized mode of functioning of such political parties, which has been further strengthened through the anti-defection law, because the members of the political party, even they can express their opinion internally, but they cannot express a different opinion electorally, that is either in parliament or in the state legislative assembly, against the party leadership or against the party high command. So there is not only a lack of inner party democracy, but because of this centralized mode of functioning of the political parties, freedom of expression also takes a hit, also because of the 10th schedule of the Indian Constitution, mainly with respect to anti-defection. So overall, we can say that the reasons for lack of inner party democracy is mainly because of culture of high command and family clout with respect to the functioning and financial aspects of the political party. And because of these two reasons, even if elections takes place, those elections are in the namesake. That is, there is no opposition and the person who stands for these elections wins unopposed. And according to the Election Commission, even such elections are valid even if there is no opposing candidate. So it is often feared by the political parties that internal elections may lead to disunity and fragmentation within a political party. And it is in this backdrop, this article also highlights an example of United Kingdom, where it says that citing the recent internal elections of Conservative Party in the UK, many have claimed that leadership polls within a party diminish its status among the voters because the contestants end up criticizing their own party's policies. And this is exactly what the political parties fear. However, when we look into the election process for US presidentship, then we see that within a political party, the different candidates fight among each other during the primaries. And during that internal fight, which takes place through successive debates, both the candidates indulge in mudslinging also. And here the news says that, for instance, Barack Obama and Hillary Clinton contested and called each other names, but then Mr. Obama won as the president in 2008 and Ms. Clinton was appointed as the Secretary of State. So there are two sides to this debate of internal elections leading to disunity and fragmentation within. On one side, it leads to greater debates. It gives more clarity about the vision of the political parties, including the vision of different candidates of the same political parties, and this also makes the voter aware about the policies which will be pursued by the successful candidate. And effectively, it helps the voters to choose the right candidate. Whereas on the other hand, certain political parties do not wish to make public their opinion, as it may lead to disunity and fragmentation within the political party. Now this article suggests that mostly the political parties within South Asia favors the idea that internal elections may lead to disunity and fragmentation within, whereas some political parties in the West favors internal debates, which not only help their political parties to redefine their ideals, but also makes the voters more aware. And also it has been stated that it is not necessary that all the individuals within a political party share the same opinion. And there can be heterogeneity with respect to opinions shared by different persons within the same political party. Now, another reason for lack of internal party democracy, particularly in India, is that procedure for their election is not entirely transparent, and it is also not regulated by the Election Commission of India, because there is no such law which mandates the Election Commission to regulate or overlook the internal elections of any political parties. Now, talking about electoral laws, under the Representation of People Act of 1951, under Section 29A, the Election Commission is empowered to register the political party. So it says that registration with the Election Commission of association and bodies as political parties. However, the RPA does not provide for deregistration of political parties. Now, under Section 29A Clause 5, it mentions about certain aspect which must be provided in the constitution of the political parties. So it highlights that the memorandum or rules and regulations of the political party must contain specific provisions that the political party shall bear true faith and allegiance to the Constitution of India as by law established, and also to the principles of socialism, secularism and democracy, and also such political parties would uphold the sovereignty, unity and integrity of India. However, the provisions is silent with respect to conduct of internal elections or overall internal regulation of political parties in India. Now, another important provision highlighted here is that any political party, after being registered, if any change takes place in their name, in their head office, office bearers or address or any other material matters with respect to the political parties, such changes must be communicated to the Election Commission without delay. And recently, some of the registered unrecognized political parties' names were deleted by the Election Commission because they did not adhere to this particular provision, and after being registered as a political party, they also did not conduct any election, and they used the benefit of being a political party to commit financial impropriety. Further, as per Section 29C of RPA 1951, the political parties are supposed to disclose the contribution in excess of 20,000 rupees received by the political party from any person or from any company in a particular year. But again, there is as such no mention of internal party regulation. And because of lack of regulations and electoral laws with respect to internal party functioning, this leads to reduced transparency within the functioning of the political party. It affects the accountability of the office bearers of the political party. Because of the culture of high command and family clout over the functioning and finance of the political parties, it often sidelines promising candidates, and this aspect also leads to criminalization of politics. And to make more dent, anti-defection laws further constrain the freedom of expression of the individual members of the political party, as they have to abide by the party high command and vote accordingly as prescribed by the political party either in the parliament or in the state legislative assembly. Because if they vote against party line, then this would attract 10 schedule of anti-defection. And all these aspects cumulatively leads to greater corruption in the political parties or in their internal functioning. So these can be said to be some of the impact of lack of internal party democracy in India. So regarding the administrative issues with respect to internal functioning of political party, there is lack of substantive powers for the Election Commission, as EC is neither empowered to regulate their internal functioning or conduct of regular election within the political party. Further, EC also does not question the result or the process followed by the political parties. Further, if elections are not conducted by the political party in a routinely manner, then the delay in such elections is liberally allowed by the Election Commission. And most disqualifications under the Representation of People Act of 1951 operates for individual members and not for political parties. So because of these reasons, there is hardly any regulation with respect to inner party democracy. And it is because of this, second ARC, National Commission to Review the Working of the Constitution, and even the 255th Law Commission report has suggested certain changes to empower the Election Commission to regulate internal functionings of political parties in India. Further, the 170th Law Commission report also recommended introducing regulatory framework governing the internal structures and inner democracies of parties, financial transparency and accountability for political parties, and these needs to be done before attempting state funding of elections. That is, before going for state funding of elections, these two aspects must be regulated earlier. That is, there is an urgent need to regulate the inner party democracies in India. Now, the Law Commission also recommended to add another provision in RPA regarding the organization of political parties on the premise that a political party cannot be dictatorship internally and democratic in its functioning outside. And also because of the fact that political parties functions both as a ruling government and also sits in the opposition. Hence, they form a part of the governmental process. And that's why the 170th Law Commission reports highlights that a political party cannot be a dictatorship internally and democratic in its functioning outside. Further, the National Commission to Review the Working of the Constitution recommended that rules and bylaws of the political party seeking registration should include provisions for declaration of adherence to democratic values and democratic norms of the Constitution in their inner party organization. Now, the second ARC highlighted the aspect of corruption with respect to lack of inner party regulation. So, second ARC in its report on ethics and governance highlighted the importance of inner party democracy and stated that corruption is caused by over-centralization. Since more remotely power is exercised from the people, greater is the distance between authority and accountability. So according to second ARC, lack of inner party regulation also leads to greater corruption within political parties. So these are some of the recommendations of 170th Law Commission report, NCRWC, and also the second ARC. Further, the 255th Law Commission report suggested to introduce internal democracy and transparency within political parties, and this should be done to promote financial and electoral accountability, reduce corruption, and improve democratic functioning of the political parties. Further, the recommendation highlights that EC should be given the power to deregister such political parties who avail the benefits of income tax exemption under Section 13A but have not contested any parliamentary or state elections within 10 consecutive years. The Commission further stated that Election Commission should be empowered to regulate the action of political parties but not their ideologies, and also to amend Section 29A Clause 5 of Representation of People Act to require political parties to insert specific provision in their memorandum to shun violence for political gains, avoid discrimination or distinction based on race, caste, creed, language, or place of residence. So these aspects must be added by the political parties in their memorandum which they submit to the Election Commission after their registration. And the Law Commission has also suggested to add another part in RPA 1951, which is Part 4B with respect to regulation of political parties. So these are some of the recommendations of 255th Law Commission report. Thus, this topic of internal party democracy is a very important topic under GS Paper 2 under Salient Features of Representation of People Act. Now, based on our discussion, this becomes your practice question for your mains examination. The question is, political parties in India cannot be a dictatorship internally and democratic in its functioning outside. Critically examine the statement and also suggest the measures to regulate internal functioning of political parties in India. This question carries 10 marks, needs to be answered within 150 words. Now, the topic of political party is very important, and this year itself, question was asked in GS Paper 2. The question was, while the national political parties in India favor centralization, the regional parties are in favor of state autonomy. Comment. And this question was asked as a 15-marker question. Now, here you need to differentiate between the functioning of national parties and regional parties, and also the larger canvas within which the national political parties operate. That is the presence of national parties in more states and union territories as compared to regional parties, because mostly regional parties are based on social engineering or caste-based politics, and the voter base for the regional parties, because of the caste-based politics or other aspects of political compulsions, is comparatively lower as compared to the voter base of a national political party. So based on this understanding, the answer to this particular question needs to be highlighted. So here we need to understand the difference of presence across the country. That is, the regional political parties have only smaller presence within a defined area or in a particular state. And such regional political parties or state political parties mostly depend on social engineering or other caste-based politics. Further, the regional political parties or the state parties also operates under financial strain as compared to the national parties, and also because of the fact that their canvas is comparatively lower. So because of these political compulsions and the fact that regional parties or state parties operate within a particular state, hence they do not favor centralization, and mostly favor federal politics, whereas national parties, since they operate at a much larger scale, at a much larger canvas, and they do not suffer from that kind of a financial strain which the regional political parties suffer, hence their politics is more towards centralization so as to increase their canvas, that is to increase their voter base across states and union territories. Now, this issue of centralization as favored by national political parties can also be understood from the perspective of simultaneous elections, as simultaneous elections are mostly favored by national parties but fiercely opposed by regional parties, because they understand that during simultaneous election, their chance of winning the state legislative assembly election diminishes significantly. And that is why they are not much in favor of conducting simultaneous elections for Lok Sabha and state legislative assembly together. So while addressing this question, we need to understand the different scenario, the different compulsions in which the national political party and regional political parties operate. The next article to be discussed is about the conduct of census, which is done every 10 years by Ministry of Home Affairs. Now this article suggests that so far for the year 2021, the conduct of census has yet not been affirmed by the central government, and it is in this regard the article suggests that it is very important to conduct census, as it is not merely about counting people, but it tells something more, which basically is that the conduct of census by the government helps in policy formulation for different caste and also class of people. Conduct of census also helps to debunk various myths and prejudices which prevails in the society, and also throws light on the nature of Indian society. And because of these reasons, it's important to conduct the decennial census, which is conducted every 10 years. Now, examples have been highlighted in this article as to why conduct of census becomes important and how it helps to debunk some of the myths and prejudices. And the first example highlighted here is regarding the issue of sun bias, which was reflected through the data collected from 1961 to 71, as it highlighted skewed gender ratio. And this was because citizens in India then favored son as compared to girls, and this period witnessed more death of girls, or we can say murder of girls, both born and also unborn. So the data reflected through the 1971 census apprised the society about the sun bias and also the killing of girls which was taking place in the Indian society. Now the article suggests that census exercise has also helped to debunk another myth, which is the issue of population explosion, particularly among Muslims in India, as there is a general perception that Muslim reproductive rates are much higher, and this is leading to population explosion in India. So the census has revealed that total fertility rate in India is falling in India, and that too at a much higher rate. Now, total fertility rate refers to average number of children born to a woman during her entire lifetime. And according to census data, this has reduced rapidly in India, and the fall in total fertility rate among Muslims is faster than any other community. Further, the 2011 census also debunked another myth that the divorce rate in India is higher in the urban areas as compared to the rural areas. However, the data reveals that the difference is not that much, as the urban divorce rate is at 0.89%, whereas the rural divorce rate is at 0.82%. So there is not much of a significant difference between urban India and rural India. So it is based on these understandings, the author suggests that the government must conduct the 2021 census, as conduct of census goes beyond mere counting of people. So talking about census, let's go through some of the important highlights with respect to conduct of census by the government every 10 years. So it provides information with respect to size, distribution, socio-economic situation, demographic and other characteristics of India's population. And the data collected through the census exercise is used for the purpose of administration, planning, policy making, as well as management and evaluation of various programs by the government, NGOs, researchers, commercial and also private enterprises. Now, whatever data is collected through the census exercise is confidential in nature, and it is not shared either with any government agency or with any private institution. Now, regarding the 2021 census, the government had earlier highlighted that along with the conduct of census, updation of NPR data will be done, that is data of National Population Register. So it says that certain information collected under the NPR will be published in the local areas and will also be invited for recording of objections. And after the NPR has been finalized, the database will be used only within the government. The responsibility of conducting the decennial census rests with the Office of Registrar General and Census Commissioner under Ministry of Home Affairs. Please remember this as your important prelims pointer. And conduct of census in India is guided by the Census Act of 1948. Now let's go through the history of the conduct of census in India. And for the first time, the census was conducted in 1872, although in a non-synchronous manner between 1865 to 1872, that too in different parts of the country. However, this effort has been popularly labeled as the first population census of India. However, 1872 census did not cover all territories possessed or controlled by the British government. And in 1881, the first synchronous census in India was conducted when W.C. Plowden was the Census Commissioner of India for the 1881 census. And since 1881, census have been undertaken once every 10 years in India. Now, post-independence, the first census of independent India was conducted in 1951, which was the 7th census in its continuous series. And Mr. M.W.M. Yeats was appointed as the Census Commissioner for 1951 census, but he was later replaced by Mr. R.A. Gopalaswamy due to his death. So these are some of the important highlights with respect to history of conduct of census in India. The next news to be taken up appears on page number 16, and this news highlights about the Indian Telecommunication Bill of 2022, which the government has floated as a draft. This news says that Telecom bill moots licensing of OTT apps dues waiver. So the government of India, in order to consolidate the old laws pertaining to the telecommunication sector, has introduced this new telecommunication bill. So the purpose of this particular bill is to consolidate old laws with respect to the telecommunication sector. And these old laws are Indian Telegraph Act of 1885, the Wireless Telegraphy Act of 1933, and the Telegraph Wires Unlawful Possession Act of 1950. So the idea is not only to consolidate the old laws, but also to address the advancement of technology, particularly in the telecommunication sector, and therefore including the OTT platforms, which is the over-the-top platform such as WhatsApp, Signal, Netflix, as WhatsApp also enables video and voice calls. So the idea is to address the inclusion of technological innovation and expansion, such as inclusion of 5G, Internet of Things, machine-to-machine communication, etc. So there is a need to regulate this expansion of technology, particularly in the telecommunication sector, and also to ensure deepening of digital inclusion at the grassroots level, including laying down the optical fiber network in the panchayats of India. So it is in this regard the Indian Telecommunication Bill tries to address all these aspects, including the aspect of telecommunication infrastructure, as it is also a key driver of economic and social development. Further, the bill also aims to develop the telecom manufacturing ecosystem in India and also restructure certain regulatory aspects of TRAI, that is Telecom Regulatory Authority of India. Further, the bill also provides for the aspects of restructuring or defaults in payments, including insolvency of agencies or organizations in the telecommunication sector, and the bill also provides for provisions pertaining to regulatory sandbox. Now, the bill explains regulatory sandbox as a framework of special terms and conditions of a license, registration, authorization, or assignment, which allows persons to conduct live testing of products and services in a controlled environment under the supervision of the central government. And here it highlights that the central government, for the purpose of encouraging and facilitating innovation and technological development in telecommunication sector, shall create a regulatory sandbox in such manner as will be prescribed by the central government. Thus, the Telecommunication Bill not only aims to consolidate the old laws of telecommunication sector, but it also aims to amend the existing laws governing provisions relating to development, expansion, operation of telecommunication services, telecommunication networks and infrastructure, and also with respect to assignment of spectrum. So with respect to the Telecommunication Bill of 2022, let's go through some of the changes which it has suggested. So the first change, which we have already discussed, is inclusion of new age over-the-top communication or OTT communication services like WhatsApp, Signal, Telegram and also Netflix in the definition of telecommunication services. This will be subject to licensing for providing services. TRAI Act, that is Telecom Regulatory Authority of India Act, mandates the Telecom Department to seek the regulator's views before issuing a new license to a service provider. Now, this proposed bill has done away with this particular provision. So, in a way, it has reduced the role of TRAI, that is Telecom Regulatory Authority of India, particularly with respect to regulators' view regarding issuing of new license to a service provider. Further, the new bill has also removed the provision which empowered TRAI to request the government to furnish information or documents necessary to make this recommendation. So according to this bill, TRAI will not be able to request the government to furnish information or documents which is necessary to make any recommendation. Now earlier, if the Department of Telecommunication did not agree with the recommendation of Telecom Regulatory Authority of India or suggested any modification with respect to the recommendations of TRAI. So regarding those modifications, the suggestion of TRAI was necessary. Now this provision has also been done away with as per the Telecommunication Bill of 2022. So it says the bill also proposes to remove the provision where if the DOT cannot accept TRAI's recommendation or needs modification, it had to refer back the recommendation for reconsideration by TRAI. Another change is regarding the insolvency aspect. So it says if a telecom entity in possession of spectrum goes through bankruptcy or insolvency, the assigned spectrum will revert to the control of the center. And the center is also empowered to defer, convert into equity, write off or grant relief to any licensee under extraordinary circumstances, including circumstances of financial stress, consumer interest, and maintaining competition in the market, among other things. So in cases of solvency, central government also has power to write away the debt or provide relief to agency under financial stress. Now another change is with respect to Universal Service Obligation Fund. Now this fund is a pool of fund which is generated by collecting 5% service charge by the telecom operators on their adjusted gross revenue. So this bill proposes to replace the Universal Service Obligation Fund with the Telecommunication Development Fund. So these are some of the changes which has been suggested by the Indian Telecommunication Bill of 2022. Now as of now, this is just a draft bill and comments have been sought from specialists and important stakeholders in the telecommunication sector. Now this topic with respect to Indian Telecommunication Bill of 2022 becomes important from the perspective of governance and also economy under GS paper 3 with respect to infrastructure. Now let's look into this news appearing on page number 12. Now this news says that Punjab calls assembly session on 27 September to knock on Supreme Court's door. Now although this is a political news, but we need to know about Article 174 and Article 164 Clause 2. As it deals with summoning of the House by the governor. So this news highlights that the Aam Aadmi Party in Punjab wanted to show off their strength and wanted to bring a confidence motion as the Council of Ministers under Article 164 Clause 2 are collectively responsible to the State Legislative Assembly. And accordingly, the Aam Aadmi Party government in Punjab wanted to bring a special session to showcase their strength on the floor of the House. However, the governor of Punjab withdrew the order of summoning of State Legislative Assembly. Now, Article 174 mentions about sessions of the state legislature, prorogation and dissolution. And it says that the governor shall from time to time summon the House or each house of the legislature of the state to meet at such time as he thinks fit. But 6 months shall not intervene between its last sitting in one session and the date appointed for its first sitting in the next session. Further, the governor may also from time to time prorogue the House or either House and dissolve the Legislative Assembly. So from your prelims perspective, Article 174 and also Article 164 Clause 2 becomes very important as questions have been asked in this very nature. Now regarding the summoning of session by the governor, the question arises as to whether this power of the governor is a discretionary power or whether the governor has to summon the House based on aid and advice of his Council of Ministers. So that is the real question. Now, similar situation arose way back in 2020 in Rajasthan, and there was conflict between the governor and the elected government, especially with respect to summoning of the house. And in this regard, the Supreme Court has also stated that power of the governor to summon the house has to be done based on aid and advice of the Council of Ministers and cannot be done in a discretionary manner. So on this note, let us go through the Supreme Court judgment and also regarding power of governor to summon the house. Now, in order to understand the role bestowed to the office of governor, we must understand two things: that the governor functions as the agent of the center and also that he is the head of the state. But the question is, which one he is more? That is, he is more of an agent of the center or he is more of a head of the state. Now, to understand this, we need to go through certain historical backdrop, especially with respect to India gaining independence in 1947. Now, in those times, when India got its independence, apart from the states, there were also princely states which exerted its freedom from the central government. Now, various role of the governor was envisaged and fiercely debated in the Constituent Assembly. However, in the backdrop of these princely states exerting independence, it was decided that the governor must be an agent of the center along with being the head of the state. And it is because of this he was given certain discretionary power under Article 163 of the Indian Constitution, so that if any state goes against the central government, then such state can be controlled directly by the center through Article 356 of the Indian Constitution. Or in other words, if the constitutional machinery in a state fails, then the governor, without taking the aid and advice of the Council of Ministers, can directly report to the President about such a constitutional failure of machinery in the state. And based on this understanding and also the then consideration of the fact that some of the states or princely states were exerting independence from the central union or central government, it provided certain discretionary power to the office of governor. But the Constitution did not limit or did not provide the factors or the grounds on which the governor can act in his discretion explicitly. So, Article 163 says that there shall be a Council of Ministers with the Chief Minister at the head to aid and advise the governor in exercise of his functions, except in so far the governor is by or under this Constitution required to exercise his functions or any of them in his discretion. So, it is because of Article 163 there are certain discretions which has been given to the office of the governor which he may use while functioning either as the head of the state or as the agent of the center. And with respect to the removal of governors, the Constitution bench under BP Singhal versus Union of India highlighted about the dual role of the governor as an agent of the center and also as the head of the state. Further, Supreme Court also held that there may be instances of conflict between center and states where the governor has to act neutrally. So the very idea of providing certain discretionary power to the governor was to maintain a strong union so that states did not wither away from the union, and in case of constitutional failure of a machinery under Article 356, the governor could directly report to the President of India. Now, despite this provision of discretionary power, this discretionary power is somewhat limited also. That is, the governor cannot act in his discretion on every matter. And here the case of Shamsher Singh becomes important. So the Supreme Court in Shamsher Singh stated that the governor has no right to refuse to act on the advice of the Council of Ministries. Now, such a position is antithetical to the concept of responsible government unless such discretionary power has been explicitly provided. Now, this idea of discretionary power was further explained with respect to Article 174 of the Indian Constitution. Now, Article 174 of the Indian Constitution states about the sessions of the state legislature, prorogation and dissolution. Now, it says that the governor shall from time to time summon the house or each house of the legislature of the state to meet at such time and such place as the governor thinks fit. But 6 months shall not intervene between its last sitting in one session and the date appointed for its first sitting in the next session. And Article 174 Clause 2 says that the governor may from time to time prorogue the house or either house and dissolve the legislative assembly. So it talks about both summoning of the house and also proroguing and dissolving the legislative assembly. So as you can understand, the whole issue of discretionary power or acting on the advice of Council of Ministers has arisen number of times in the past as well. So in the Nebam Felix judgment, the Supreme Court decided that the governor can summon, prorogue and dissolve the House only on the aid and advice of the Council of Ministers with the Chief Minister as the head and not at his own, that is not in his own discretion. And the court also gave its decision based on the discussion in Constituent Assembly debates, whereby it was finalized not to give discretionary power to the governor under Article 174 of the Indian Constitution with respect to summoning, proroguing and dissolving the House of State Assembly. Now similar discrepancy happened in Rajasthan in July 2020. Now the Chief Minister wanted to convene the State Assembly of Rajasthan, however the governor refused. So the whole question which arose was whether the governor has discretionary power to summon the House as per Article 174 of the Indian Constitution. And in this regard, the Nebam Felix judgment of the Supreme Court has clearly stated that it is not in his discretionary power of the governor to either summon, prorogue or dissolve the House. And in this regard, the Supreme Court also discussed about the debates which took place in the Constituent Assembly to understand whether discretionary power was given to the governor under Article 174, which was the draft Article 153. So it says that referring to the discussion in Constituent Assembly, the Supreme Court noted that framers of the Constitution expressly and consciously left out the vesting of powers to summon or dissolve the House solely with the governors. So this power must be exercised with the aid and advice of the Council of Ministers. So the Supreme Court discussed about draft Article 153, which became Article 174 in our present Constitution. Now this draft Article 153 provided discretionary power to the governor. However, during the discussion in the Constituent Assembly debates, this discretionary power was removed from draft Article 153 while the Article 174 was being drafted. So it says that draft Article 153 was substantially altered to indicate that the Constitution framers did not want to give governors the discretionary power. And after looking into the debate, the Supreme Court in Nebam Felix case clearly stated and concluded that the only legitimate and rightful inference which can be drawn is that the framers of the Constitution altered the original contemplation, that is, they altered draft Article 153 and consciously decided not to vest discretionary power with the governor in matters of summoning and dissolving the House or Houses of State Legislature. And this was done by omitting sub-Article 3 of the draft Article 153 of the Constitution. So the Supreme Court decided that the governor can summon, prorogue and dissolve the House only on the aid and advice of the Council of Ministers with the Chief Minister as the head and not at his own. So after understanding about these important judgments, let's understand about certain discretionary powers of the governor which can be inferenced while going through the provisions of the Constitution of India. Now the first is to reserve any bill for the consideration of the President under Article 201. Next is to appoint the Chief Minister of State under Article 164 Clause 1, including inviting the leader of single largest party in case of a hung verdict so that they get a chance to prove majority on the floor of the House. Next, to dismiss the ministry also, as the Chief Minister and other ministers also hold office during the pleasure of the governor. Governors report under Article 356 in case of failure of constitutional machinery in states, and governors' responsibility for certain regions such as tribal areas in Assam and responsibilities placed to the governor under Article 371A with respect to Nagaland, 371C with respect to Manipur and 371H with respect to Arunachal Pradesh. Now these are some of the special provisions provided in the Constitution of India. The last news for our discussion appears on page number 10 in the text and context section, and this news is with respect to Nikah Halala. Now way back in 2017, the Supreme Court had declared the practice of triple talaq as unconstitutional, as arbitrary, being discriminatory of gender and also against equality. However, the Supreme Court judgment did not dealt on either polygamy among Muslims or the aspect of Nikah Halala. So here let us understand about Nikah Halala and also let us understand what does the petition of the women seek. So this news highlights that the case of Nikah Halala in India and a long court battle. What is it and why are women seeking an annulment of Halala marriage? How does it affect Muslim women of the country? And when is the court going to hear it? So after the Supreme Court judgment of 2017, when triple talaq was declared as illegal, the government enacted the Muslim Women Protection of Rights on Marriage Act 2019. And this also made the pronouncement of triple talaq by Muslim men as a criminal offense. However, this legislation did not deal either with polygamy or with the aspect of Nikah Halala. And it is because of this, women in the Supreme Court have asked to declare Section 2 of the Muslim Personal Law Sharia Application Act of 1937 as violative of Article 14, that is equality, Article 15, that is prohibition of discrimination, Article 21, that is right to life and personal liberty, and Article 25 of the Indian Constitution with respect to right to religion. Now this particular section deals with the personal laws of Muslims. And here, among other things, it also deals with marriage, dissolution of marriage, including talaq, maintenance, dower, guardianship, and trust properties. Further, the petitioners, who are Muslim women, have also asked to declare Nikah Halala as rape under Indian Penal Code, which is section 375. So here let us understand what Nikah Halala is. Now suppose if a man has given triple talaq to his wife. Now if the wife intends to remarry the same person again, then she has to go through a very long process, as in order to remarry the same person, the wife has to marry another person, consummate the marriage, then take divorce, and then observe a separation period. So this becomes very tedious, and at times even sham marriages are conducted or observed just to facilitate Nikah Halala. So one of the conditions under Nikah Halala is that the woman has to remarry another person and also consummate the marriage and then take divorce, observe the separation period, and then remarry this person. So it is because of marriage with another person and then also later divorce, the petitioners, who are Muslim women, have sought to declare Nikah Halala as rape under Indian Penal Code of section 375. And this very serious situation will be heard by a 5-judge constitution bench. And here the Supreme Court has also sought opinion from National Human Rights Commission, National Commission for Minorities, and also National Commission for Women. So as of now, this is a developing story. Let's wait for the final verdict of the Supreme Court, especially with respect to the issue of polygamy and Nikah Halala among Muslims in India. Now this news becomes important mainly from the perspective of rights issues and also gets covered under GS paper 2 regarding significant provisions of the Indian Constitution, and also GS paper 1 regarding Indian society. So with this we come to an end to today's discussion. Thank you for watching DNS.